Good evening, friends. As the journey of understanding the Constitution and enjoying the spirit of Constitution in respect of 75 years of its coming into being, this series has been started, and we believe that we will complete the 75 sessions on the understanding of different facets of Constitution of India. Though prior to this, we had connected with Mr. Subramanyam Sriram, today's eminent speaker, a senior advocate and a former Advocate General from Andhra Pradesh. But as they say that things are deemed to be when it is destined to be. And the aspect of reservation is also not from today, but it is ages, I can say, since from the Constitution of India. To understand the nuances of reservation under Article 15 and 16, the enablement and the limits thereon, especially with reference of Indra Sawhney case, we take today's session part 5 in respect of Constitution of India. We are glad that Sir has accepted our invite. And whatever little discussions we had prior to the session, I can say with strong belief that there will be too many brownie points for understanding this facet within the short journey of 45 minutes. Sir always gives a structured prism to understand things, but I will not take much time. I will straightaway ask Sir to give a bird eye view in respect of the Indra Sawhney case and what did it lay down and whether it still holds good or how the journey in the legal parlance has actually moved forward. Over to you, Sir.
Thank you, Vikas. Good evening, Vikas, and all the participants. I'm thankful for the opportunity that Vikas had provided to me to get in interaction with you all. Am I audible?
Yes. Yes, sir.
So, when it is the Constitution we are expounding, said Justice Marshall, it is with a deep sense of understanding of the transformative document that law courts have approached any of the complex questions which have come to court. And if there has been one repeated issue which has been engaging the attention of the Supreme Court very regularly, it's about the scope of reservations, the need for reservations, the limits thereon, and as to how each one of those areas will have to be read and understood in the context of an otherwise egalitarian society, etc. So before we move to why and how of Indra Sawhney happened, we need to also perhaps navigate through where and how the starting point of elements of protective discrimination had begun. In the southern part of India, elements of protective discrimination, and I use it broadly as inclusive of concessions, exemptions, and also as an act of reservation, predated the Constitution. So with the advent of the Constitution, and more particularly with the positive injunctions of 15.1 and also the prohibited zones under 15.2, the first of the cases, and quite rightly, came from Tamil Nadu, which was colloquially, which is now referred to as the communal roster case, or what is the Champakam Dorai Raj. The communal roster in the state of Chennai, the state of Madras then, had indicated the number of seats each caste, a person belonging to each caste, would take. And when the Constitution was adopted, and our first text of Constitution did not have Article 15.4 of the Constitution. Therefore, in 1951, the Supreme Court took the view that caste is a prohibited norm of identity-based exclusion or inclusion for admission to educational institutions, and therefore identifying the number of seats per caste, therefore clearly violates Article 15.1 of the Constitution, and it was accordingly struck down. Right about the same time, there was a communal roster for public employment as well. and 16.4 was part of the original text of the Constitution itself, which enabled the state to make provisions for other backward classes who are underrepresented in the services of the state. So the communal roster there indicated that one caste will have these many positions, another caste will have those many positions. And in regard to other religious identity, they said that this can be filled up only by those people who belong to that particular religious denomination. So Venkatramana versus State of Madras, which happened in about the same year, had two distinct pronouncements of law. Provision of reservations for public employment, in which, in the opinion of the state, was underrepresented by a few communities, was held as enabled under 16.4. But nevertheless, communal roster for employment was also struck down on the ground that a few named castes amongst the Hindu religion are, by reason of that caste identity, not made eligible to apply for positions which are earmarked for other religious groups being non-Hindus. So just as with the present times, and the country was going through a process where it had to keep its tryst with destiny, as the first Prime Minister had spoken, the Parliament responded. In perhaps the first of the instances to what is called removing the basis of a judgment by a legislative intervention, Article 15.4 was added to the Constitution, which in text is not pari materia with 16.4, because we have, in regard to text, a distinct language which in the ultimate analysis did not amount to much, because by judicial interpretation, law courts have held that the parameters of who will constitute backward classes would more or less remain the same, which I'll allude to later. It introduced a provision in the form of 15.4, which enabled the state to take measures or make a special provision for the advancement of socially and educationally backward classes of citizens of the scheduled castes and scheduled tribes. So how did this enablement change the course of law? Just to make the narration complete, we have also more or less a similarly worded the 14th Amendment to the US Constitution, which does not have the similar enablement as is under 15.4 and 16.4. But Brown versus Board of Education and a whole body of law then had indicated that in the event of a provision being made by a state which identifies a few minorities for acts of protective discrimination, since it prima facie and ex facie goes against the text of the 14th Amendment itself, such acts or legislations will be viewed as suspect legislations, and strict scrutiny will be the tool by which it would be unraveled by the law courts. But that distinction or that particular mode of judicial review or constitutional law challenge would not apply to us, because after the First Amendment to the Constitution, 15.4 and 16.4 ranked together to the extent of enabling the state to come up with a positive provision providing for emancipation of socially and educationally backward classes for 15, and backward classes who are underrepresented in the services of the state for the purposes of 16. What then happened between 1951 to 1964 is that there have been cases and instances, mostly in the south of the country, where the identification of backward classes and as to what could be the objective criterion, therefore, had been engaging the attention of the courts. The first judgment that came after 15.1 came by is Balaji, which is in 1964. It's important for us to look into Balaji, because that is when the entire gamut of what could be effectively the process of finding out who the backward classes are or SCBCs are came to be considered. This is 1963 SC 649. Now in the state of Mysore, except Brahmins by caste, every other caste was designated as BC, and then reservations were provided to the extent of 75% thereof. Therefore, the first question that was asked was that caste is a prohibited form of identity under 15(2). No citizen shall grounds only of religion, race, caste, sex, place of birth be subject to any disability, liability, restriction or condition with regard to etc. And therefore a prohibited form of identity can it be the first starting point of lending identity to finding out who is SCBC. The court held the following, and this was in 1963, that caste alone cannot be the guiding criterion. There has to be an objective criterion on what constitutes socially and educationally backward classes or who constitute it. And more importantly, they said that this enabling power is an exception to the positive injunction under 15(1), which says that state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, etc. And they limited the reservations to 50%, which has stood the test of time on almost the same logic, which we'll come to later. Of course, there was another judgment in relation what is now called Devdasan's case, and this is the first of the cases where Justice Subbarao's dissents of that time started becoming majority over a period of time subsequently in the same subject matter. Devdasan followed mostly as to what was there in Balaji, but in relation to the exceeding of 50%, it had held in relation to scheduled castes and scheduled tribes that if for a reason in a particular year, certain number of vacancies remains unfilled, if it is carried to the next year, in that recruitment numbers, if 50% is crossed, then that will be bad. Of course, Devdasan is rightly overruled subsequently. Then, after the first Kaka Kalekar Commission came the Mandal Commission. Indra Sawhney is primarily about public employment, though all of what has been held as relevant for Indra Sawhney is also relevant for 15(4), is what has been held subsequently by the law courts. So therefore, whatever is Indra Sawhney is the law for 16, is also the law for 15. The first question, therefore, that then what did Mandal Commission do? Mandal Commission identified on the basis of the handed down criterion, and Mandal Commission's search and survey on the basis of the pre-independent census has been acknowledged to be the most objective, the most searching and inquisitive line of search which is necessary for any fact-finding body to arrive at who constitutes backward classes and how they are to be found. I am primarily referring to Justice Jeevan Reddy's judgment in Indra Sawhney's case because it is now constituting majority, barring one point which came to be subsequently modified, so to speak. So what was the first question that what are the recommendations and how did the government of India implement? For the first time, they brought about 2 memoranda in implementation of the Mandal Commission's recommendations. Now, those are also referred to periodically. There was one in the year 1990, which was subsequently amended in the year 1991. The memo said the following. They said 27% of the seats which are now available in the institutions and for admissions and also services. This, of course, Mandal Commission was only in relation to services. They said 27% in civil services will be reserved for SCBCs who have been so included by the central government in pursuance of the fact finding by the Mandal Commission. The second, they said whoever is amongst these identified BCs competes with the open category candidates shall not be counted amongst the reserved categories. And they would further indicate as to how the vacancies would be applicable. And as we are all aware, as with any reservation issue, it created a huge furor, and the society was riven along the categories lines. And subsequently, after the change of government in 1990, the memo was amended, saying that the 27% reservation that we contemplated in the year 1990 will be given first only to the poorer sections of the identified SCBCs, and who will be poorer will be something that we will decide over a period of time, and only if such sufficient number of poorer sections amongst that SCBCs are not available, it will be given to the other SCBC candidates. Then they said 10% of the vacancies in civil posts shall be reserved for other backward sections. So EBC reservations seats, but not in the manner that it is now provided for under Article 103. The seed was sown in the year 1991 itself. So what were the, and by reason of the tumult and the increasing social disharmony that it had the clear potential to create, there was a litigation that was brought, and initially it was also stayed by the courts. Series of issues have been taken up for consideration. The first was, what would be the identity mark to begin? Who is a class? A class. This was major, it was a major course of discussion, while caste as an identity mark was approved in Venkatramana in 1951 itself. Since Balaji said caste cannot be the sole criterion, that question was also kept open. Among the series of questions that was decided was as to whether the provision that is to be made would be legislative or could it also be executive. Can it be done in pursuance of a political manifesto given by a political party? Then, as to who will determine the adequacy of representation in public services and what would be the basis thereof? What are the tests required to be satisfied by such people who are identified to be backward classes? If they are to be identified, what will be the total quantum of reservation that is permissible under the Constitution? What about the advanced sections of the society who perhaps rank at par with the other unreserved sections, and how should they be identified, and what would be the nature of any particular elimination process in relation thereto? Then, if is 15.4 and 16.4, are they in the nature of an exception to Article 16.1? Importantly, they found out as to what could be the basis for crossing the 50% limit. The next, whether it is a open, whether reservations can be a tool of protective discrimination only at the time of entry into service, or can it also be extended to the promotions as well? And what is, can economic criterion be the sole criterion for arriving at this basis? And the last question was as to who should be determining as to what would be the nature of the machinery or the mechanism by which a particular set of people could be identified as backward classes. Now, these are high-sounding questions, but they have been very characteristically simplified by Justice Jeevan Reddy. First, he says somebody has to begin somewhere in relation to identifying who a backward class is. If there is a collective of people who have homogeneity in the nature of occupation, in the nature of their livelihood earning capacities, in the nature of similarity about how backward or forward they are in terms of educational opportunities and representation in public service. Caste can be a starting point, because in India, we can't move away from caste being a mark of identity. So a caste can be a class, is in continuation of what Balaji said. Notwithstanding the fact that caste per se cannot be a ground of any further disqualification or ineligibility or entitlement under the scheme of the Equality Code under 14, 15, and 16, for the purposes of identification of backward classes, because in the majoritarian population of this country, caste and occupation and the reverse are integrally connected to each other, the Supreme Court sanctions the legitimacy to an inquiry which begins with caste. It reiterates that caste alone cannot be the criterion, but it should be caste plus. Then you take up an occupational group. They have a homogeneity of being a collective. There is endogamous relationship. They're all stuck together by a process of culture, eating habits, etc. Now a group is identified willy-nilly, it is called a caste. After identifying that collective, we have to also identify what is their population in relation to the national or the state's population. After coming to these figures, which will have to be on the basis of an objective criterion, one has to consider as to what is the national average of presence in education, presence in employment, and see as to what is their average. If by reason of they being not high up in the hierarchy of the Chatur Varna, which primarily defines the Hindu society, then the first element is to find out whether they are socially backward, because the expression used is for the purposes of 15, it has to be socially backward. So in the pecking order or the epistemic social order of the Hindu society, if a person or a group of persons by reason of their occupation have been found to be amongst the Chatur Varna in the lowest order, then they will have to be treated as socially backward. They would identify Shudras and other scheduled castes and scheduled tribes in particular relation to Hindu community, and they would say they are socially backward because they are not mainstreamed into the process of the society building, the governance, and or in the distribution of the state largesse. So once you identify a caste, you will find out whether in the social order they are socially backward or forward. If they are socially forward in terms of public esteem, which is writ large in the caste system of this country, you have a class which is socially backward, but that is not enough. You will have to also find out whether they are educationally backward. So by reason of how the society of the majoritarian community in the country has moved forward, the court finds that social and educational backwardness are so interlinked to each other, because social backwardness leads to non-enrollment in areas of education. Non-enrollment in areas of education would mean that they do not qualify for being appointed to public employment, and therefore this is a vicious circle. So a caste is identified. In the social esteem, it is found out whether it is ranking at par with what is considered as the upper echelons of the society or they're lag behind. And then by an objective criterion in comparison to the national average, in relation to other castes or other groups, if they are backward, then we have a caste that is socially and educationally backward. This is for the purposes of Article 15. But for Article 16 does not use socially and educationally backward. It only uses the words back in favor of any backward classes of persons who are underrepresented. So the court finds that as regards the contextual and the textual change in the manner of wording of 15.4 and 16.4, social backwardness is common for 16.4, but one additional test is that they should be underrepresented in the services of the state. There are many instances in this particular country, a diverse country as we are, that a few castes or few classes who are otherwise backward classes have more than the required representation in public services, either because of historical reasons or particular social reasons in that state. So whoever is socially backward for 15, ipso facto is socially backward for 16. But he will be entitled to reservation, that class will be entitled to reservation only if by data they are shown that they are underrepresented in the services of the state. So if 15.4 and 16.4 go together, and by judicial construct, by reason of subsequent judgments, they have said, and the court also finds that even though socially and educationally backward, these words are not in 16.4, any underrepresentation in the services of the society, in the more particularly in the majoritarian society, is only on account of social and the consequential educational backwardness, and therefore there is not much distinction. Therefore, you will see that all the states which have a 15.4 list will have the same list for 16.4 as well. So therefore, there is an equalizing of parameters for finding out who is socially and educationally backward for the purposes of Article 15.4 and who are backward classes who are to be provided positive measures in order to secure adequate representation in the services of the state. Now, there is a lot of discussion on what is adequate. The law is adequate is not proportionate. The backward classes of citizens as included in 16.4 also include scheduled castes and scheduled tribes, and they are by reason of historical discrimination and rough practices, they are treated as backward classes of citizens, perhaps suffering more backwardness than the backward classes who have been identified by in pursuance of an inquiry such as the Mandal Commission. So by reason of Article 330 and 332 of the Constitution, which I'll advert to later, the courts have leaned in favor of proportionate representations as regards scheduled castes and scheduled tribes, though it is about their political representation. 330 is in respect of scheduled castes and Anglo-Indians is for 332, but that is for political representations. But courts have allowed this principle of proportionate reservations for scheduled castes and scheduled tribes. And as far as the backward classes other than the scheduled castes and scheduled tribes, they have said it is not in relation to the population. They have to be only ensured that they have adequate representation, and the debate is still on. So that distinguishes the backward classes and scheduled castes and scheduled tribes in relation to the numbers of the reservation. If there is a 16.4, is it an exception to 16.1? Is an important question that they had to decide. Balaji had decided that 15.4 is an exception to 15.1 because there is a prohibition of discrimination on any ground. If there is an enablement to create protective discrimination, it can only be treated as an exception, was the judicial principle that was evolved. Devdasan carries forward the same with a compelling dissent by Justice Subbarao saying that 15.4 is not an exception. It is a classification implicit in Article 15.1. Where does this judicial or the legal principle come from? Article 14 postulates equality before law and equal protection of the laws. By reason of the march of the law, the courts have evolved two principles that Article 14 does not prohibit classification, but only bars class legislation. And if there is a classification of people which stands on intelligible differentia with nexus with this object sought to be achieved, that power to classify, to bring in substantive equality is implicit in Article 14. While there is a positive mandate of declaration of equality of law, courts have held you can classify unequals to be treated unequally and equals to be treated equally, and that is when you can bring in the equality, and therefore Article 14 does not bar classification. So therefore, Balaji had to be reconsidered as to whether 15.4 is an exception. After surveying the entire law in this regard, Justice Subbarao's dissent in Devdasan is approved in Thomas. Thomas in 1960s came about, which said that 15.4 is not in the nature of an exception. 15.4 is in the nature of the classification which is implicit in the state's mandate not to discriminate. Therefore, if there are positive grounds for protective discrimination that is implicit in 15.1, this power to provide reservations on finding out certain SCBCs is an instance of classification under 15.1, and it is not a proviso. It is important as to what distinction it makes between 15.1 and 15.4, if it is a proviso, if it is a classification. Reservations on the basis of SCBC categorization is not the only basis for protective discrimination. There are other areas of classification which could be on the basis of, while we see most of these litigations concerning educational institutions, we have quotas for in-service candidates. We have horizontal reservations for physically handicapped, for NCC cadets, and for a few others. Therefore, if SCBCs are the only people that can be given reservations, there can't be anybody else because there is no enabling provision. Therefore, Supreme Court says, power to classify is implicit in 15.1. 15.4 and 16.4 is an instance of providing for protective discrimination for backward classes, but it is not exhaustive of all the concepts of affirmative action. There are other areas of classification which can be undertaken under 15.1 and 16.1, and that's how you have horizontal reservation, not for women, for disabilities, people with disabilities, the NCC cadets, the sports quota, the in-service candidates, etc. I'll come to horizontal a little later. So therefore, it was important to ensure that 15.4 is not treated as an exclusive proviso admitting for protective discrimination only for SCBCs. If there are any other classes who are required to be protected by other processes, who may not be socially and educationally backward, but they may have to be provided a handicap or an incentive or a promotive, Therefore, if it is implicit and if it is seen as one aspect of classification that it can be given for SEBCs, it achieves both the objectives. So on sound jurisprudential logic, it was found that 15.4 and 16.4 are not respective exceptions to the main provision. The next question was, what do we do with the advanced sections? Because the amended memorandum said it will be first offered, the 27% will be first offered to the poorer sections amongst the SEBCs, and if there are no takers, then only it will be given to the other SEBCs. The majority agreed that if there are groups within that group of SEBCs who have attained such a level of advancement so as to compete with the other sections of the society, they have to be excluded from the fruits of this affirmative action, though they may belong to the same caste and same occupation and other dimensions of homogeneity. For in order to bring about equality and forms of protective discrimination by reservation, in order to ensure that it reaches the desired, the deserving needy, then such of those people who have crossed the needs for reservation in terms of opportunities, in terms of their income levels, and in terms of their social advancement associated with their education opportunities and employment, because it is important that a man moves up the social ladder. In Hyderabad, I call them the Banjara Hills class. So if the distinct elimination of creamy layer should be clear from the strides these individuals make, and there can be a process of exclusion of this creamy layer from amongst these SEBCs from the fruits of reservations, though they may continue to be in the same caste. The other question, and the vexed question, as has now been found out, is as to whether the reservation should be limited only at the entrance stage or it should go on to promotions also. The Supreme Court, as 16.4 stood then, held that it is only at the stage of initial entry. Then the Parliament responded. It came up with what is called the 16.4a, which said that Indra Sawhney had said that it is only limited to this particular aspect of entry level, but we will also give it at promotion level. Then 16.4a resulted in what is called the Ajit Singh 1, the Ajit Singh 2, which said that if there is a reserved candidate who's getting promotion out of turn and steals a march over the other, gets a march over the other, when the other person catches up, when the unreserved person catches up on promotion, he should be considered senior in relation to the reserved candidate. Then it resulted in another amendment by reason of 85th Amendment. They said that it is for the Parliament to decide as to whether seniority should be given to the roster point promotee and whether there should be a catch-up rule. It is not for, and the absence or presence of that catch-up rule does not violate any fundamental right to promotion of others. There is also another parliamentary intervention. Supreme Court said a year shall be taken as a unit and not all the years, because if in this particular year it was found that particular people, the particular classes are underrepresented, all of them can't be brought in here. 1 year should be taken as a unit. Since it was getting difficult to operationalize this year as a unit, then 81st Amendment came to bring in 16.4b. All the three were challenged in M. Nagaraj, and Nagaraj upheld the principle in 2006 8 SEC page 1 that so long as the state shows that there is underrepresentation and there is an enabling provision for considering reservations for reserved categories for promotions, if it is backed by quantifiable and qualitative data that they are underrepresented, promotions can be granted. It is no part of the basic structure for the people unreserved who get promoted subsequently to claim accelerated seniority. It is for the state to provide, and the constitution and the challenge to constitutional amendments had been struck down. So Indra Sawhney was preceded by constitutional amendments and succeeded by constitutional amendments. Indra Sawhney said economic criterion cannot be the sole basis for creation of 10% reservations for other reserved categories. And that paragraph of 1991 memorandum, which was brought about to create social harmony amongst the economically backward, also was struck down. Then, since it was struck down in the context of 15.4, the Constitution is amended by the 103rd Constitutional Amendment, which said that nothing in this article shall disable the state from providing for any measures for economically backward classes to those classes who are not already getting any reservations. That is, such of those economically backward class citizens who are not backward class for the purpose of 15.4, 16.4, but on economic grounds it shall be open to the state to provide reservations. The state provided 10%. It came to be challenged. The majority in the EBC case, in the 103rd challenge case, has held that Indra Sawhney's ruling that economic criterion cannot be the basis for reservation is to be seen as limited in the context of 15.4 and 16.4 being considered for securing substantive equality under 15.1. If economic basis can be a structured basis for classification, there is no violation of the basic structure doctrine at all, was the case law. Then the most often and the repeated question is how to cross 50%. The recent example we have is of the Maratha reservation. Supreme Court said that 50% is the rule because Article 14 has to be harmonized with Article 15 and 16.1. Of course, we have to provide for reservations for a few people in order that equality be obtained. But in case we have to harmonize both the provisions, it is appropriate that it should be kept at 50%. 50% is the advisory cautionary rule, but it is not an inviolable rule so long as the state can prove that in far-flung and remote areas, there have been populations which have not been mainstreamed. So this particular paragraph was quoted by the state of Maharashtra in support of Maratha reservation to say that they are this much of population, they are underrepresented by this much, and therefore 50% is not an inviolable rule, and there are extraordinary circumstances. In the Maratha reservations case, in fact, all these citations are there, I'll share it with Vikas. The court held that crossing 50% is on the three tests. One is a certain population is far-flung and remote who have to be mainstreamed into the society. And in the instant case, the class which was sought to be included into the reserved classes exceeding 50% are neither living in remote areas or far-flung areas, nor are they outside the mainstream. So many chief ministers have belonged to this class. This is the percentage of educational presence. This is the percentage of representation. And therefore, this particular crossing of 50% is unconstitutional, is what the court has held. What has been further held in Indra Sawhney is that there can be backward and most backward. And that will have to be ascertained in relation to the inter se classification between who have already been identified as backward. And there is no prohibition for further subclassification, and the same doctrine has also been followed now in the SC subclassification case, which has also now been reported, where they have said that subclassification amongst SCs, provided there is concrete data about the classification standing the test of its own, can be conducted in respect of SCs as well. One major point is about creamy layer. Supreme Court said creamy layer is only applicable to backward classes and it is not applicable to scheduled castes so far as Justice Jeevan Reddy is concerned. In fact, it is tabulated into brackets in parentheses in paragraph 792. Subsequently, Indra Sawhney 2 and also in Jarnail Singh's case, the Supreme Court has found that the majority judgment did not exclude creamy layer as inapplicable to scheduled castes outright. It is open to Parliament to prescribe creamy layer, even in regard to scheduled castes, and which has been reiterated by one of the concurring opinions in the subclassification judgments by Justice Gawai. So if there is one movement forward, one movement away from Indra Sawhney's ruling, the caveat that Justice Jeevan Reddy's majority opinion said that this creamy layer is only limited to backward classes and it is not being spoken to for scheduled castes and scheduled tribes has now been moved away from. Thomas and Jarnail Singh have been quoted in support of the principle that if the Parliament is so desirous of creating a creamy layer amongst SCs also, that can also be done. So therefore, 50% is the rule. Caste can be a class. The reservations are now available for promotions as well. Promotions don't have to necessarily mean catching up rule in seniority for the other unreserved categories. If reserved categories compete with unreserved categories, they will not be treated as reserved quota. They will be treated as open category. 50% is more or less the rule which has not been successfully violated so far. So far as the judicial tests are concerned, except in one case which is still pending challenge. There can be subclassification amongst backward classes. There has to be an objective criteria which should include the tests of social backwardness, educational backwardness, occupational backwardness, income levels, etc. for 15.4 and 16.4. And as far as the subclassification is concerned, it is open to the state to undertake that exercise as well. And since it continues to be a matter that engages the attention of succeeding generations, one important question that needs to be addressed and answered is, are reservations anti-meritarian? In terms of law, in terms of social sciences, in terms of practical experience, reservations are not anti-meritarian. As has been pointed out by the Supreme Court, a pass in an entrance test and a rank in an entrance test is not the only test of merit in relation to an individual. There are other historical, social, and contemporaneous reasons which go into the merit ascertainment of an individual, and therefore reservations, if anything, are a necessary tool for achieving the broader social and economic equality in this country. And ordinarily, as with any constitutional exercise, there will also be politics, as Supreme Court has found out, and they've said there is no immunity to any of these methods or processes which lead to reservations. The courts will apply the Charter of Judicial Review as is applicable in case of a statute or an administrative action. It will ask as to whether there has been an objective criterion to find out who is socially and educationally backward class. And if it is 16.4, whether they are backward and what is their representation in government. What is the total percentage of reservations that has been arrived at? Has creamy layer been excluded? And as to whether the overall norm of equality has been complied with. Indra Sawhney has stood the test of time. Parliament has responded to remove the basis of Indra Sawhney in relation to two issues. One is about availability of reservations and promotions and about the unit being a year. And over a period of time, and it is not yet concluded as to whether who should be reserved categories and who should not be is a concluded chapter after all. It will always come back to courts. And as with the recent West Bengal judgment, which is pending in Supreme Court, and the reservations in Andhra Pradesh, which is also pending in Supreme Court, it is likely to engage with us for some more time to come. Thank you, Vikas. I've tried to capture as much as I can in this framework.
Thank you, sir. I think there couldn't have been as they say that any good speaker will always be on the dotted lines, the way you said and the way you had expressed it. It has summed up in the time limit. So few questions I've received on the WhatsApp.
Yes.
Like they say that there is a principle of catch-up. Can you elaborate what is the principle of catch-up?
Yes. So Ajit Singh 1, Ajit Singh 2, and Chauhan had indicated that when 16(4)(a) was brought about by 77th Amendment, it only added the words in the matters of promotion. So what Ajit Singh 1, Ajit Singh 2 and Chauhan had held is they are only entitled to promotion on the basis of being a reserved category, scheduled caste and scheduled tribes, and they're not being adequately represented in the promotional post. When the unreserved category who catches up with them, because if by a roster point promotion, if a reserved category has gone up, then an unreserved category who's higher up in the seniority and or merit has to make way for him. But in due course of time, he catches up. He also gets promoted. Then Ajit Singh said, when the unreserved category person gets promoted and both of them are in the promoted positions, the unreserved category person should get the consequential seniority of the lower post. Therefore, in the promoted post, the unreserved category person catches up and gets senior to him. Ajit Singh 1 and Chauhan said, this is a way of harmonizing and equalizing the growth. The unreserved candidate gets the reserved candidate gets promotion. The unreserved candidate gets promotion later, but he will not lag behind for all times to come. But his seniority in the lower category will get added up and he will be senior to the reserved category promotion who got promoted earlier. Then that resulted in the 85th Amendment saying I can create a rule which says there shall be a roster point promotion, and if that roster point results in earlier promotion ahead of time to a reserved category person, he is also entitled to seniority from that date, which means there is no catch-up rule now for the unreserved candidate.
Yeah.
Have I made myself clear?
Yeah.
This is a complex question. Yes.
That's true. The second question was as to whether in which domains the center can have its rights and where the state will have the rights for the reservation.
Now, by reason of article, and this also came up in 1 year's reservations and also in Maratha reservations, by reason of Article 340, by Indra Sawhney said there should be a permanent body which should be out of the wear and tear of local politics and it should be headed by experts, etc. And by reason of the same, National Commission for Backward Classes Commission Act 1993 came to be enacted. All states enacted respective enactments for the state. For the purposes of states admissions and state recruitment, state is a unit. It is not necessary that everybody that is a BC for the purposes of a state is also included in the BC list for the center. So every state has a list, and by reason of the declaratory clarification that was given to Article 340 after the 1 year's case, center, the National Commission for Backward Classes will take care of the central list, and the declaratory clarification that was issued under 340 to remove the basis of 1 year's judgment now clearly says that the appointment of the National Commission so appointed under 342A will only be, the president will notify the socially and educational backward classes only for the central list. And as far as the state list is concerned, it is left with the state. 342A explanation and 342(3) makes it clear. In fact, it came up for discussion in Maratha's case that the entire perhaps list is now taken over by the union by reason of giving a constitutional status to National Commission for Backward Classes. The Attorney General argued that it was not so, and what was sought to be given was only for the central list. And since it was not made very clear, the explanation had come about to say that the dispensation of Article 340 and 342A for the president to act is only for the central list. As far as the state is concerned, it is for the respective state governments.
The last question is, we also see while discussing about reservation that there should be some data quantification. What is the concept of data quantification for the purpose of reservation?
Yes. So what did the Mandal Commission do? The Mandal Commission went by a census. And there is on the basis of census, though it might change by the time it gave its recommendations, it was 1970s, and therefore it did not bear true affinity to the figures was a difficulty that has happened. What does one do with the data? The first thing they have to do is to find out the population figure of that particular class. And then find out either by a scientific survey or door-to-door survey. Most often, what they do is do a scientific survey. And the survey is also challenged in Muslims reservation in Andhra. They come to a conclusion as to how much percentage of this identified class has representation in public services and has presence in the institutions of higher learning. They will compare it with the national average and see whether they are lagging behind. This is a structured data on objective criterion, absent which any finding of fact that a particular class is socially and educationally backward will be struck down by court, as was done in Maratha. As far as promotions is concerned, the quantifiable and qualitative data which has been upheld in Journal Singh is that you have to find out as to how many promotional vacancies are there, what is the incumbency of all classes, and whether in this particular year or in this particular round of promotions, you need to allow for this entire roster point promotions to be given. If they are already there in their own right, if the reserved classes are there in their own right and or otherwise, then the courts will say that there is no quantifiable data to provide for promotions for these positions on the basis of reservation, because there is no compelling state need, nor are they underrepresented. So it's entirely about data and about the parameters of judicial review on data. The Marathas case, the 1 year's case, and the 7 judges, the 7-judge bench of AP High Court has said that they will apply the norms of secondary review. They will say if the factual data is correct, if the conclusions are objective and rational and not perverse, and if it is a case of data at all, if there is a case of presence of data at all. So they will apply the norms of secondary review and then judicially review the factual finding. I need to indicate Indra Sawhney 2 came in 2001 SEC 168. State of Kerala said in a legislation as a preamble in fact, as a legislative fact, that there is no creamy layer amongst backward classes in the state of Kerala. Supreme Court said we will apply the same principle of factual adjudication as we did in Keshav and the Bharati, and then find out as to whether this fact data is correct or not. So they applied in relation to the fact data as to whether it is bearing any nexus with the situation on ground, and they struck it down on the ground that that legislative fact is wrongly declared.
I think, sir, nobody could have elucidated in a much better fashion what you have elucidated. And we will take more sessions with you. And I'm feeling that we should have taken you much prior in such sessions. You have such an epitome of knowledge. Thank you, sir. And thank you.
Thank you. Because thanks for all the participants or participants.